For those of you who don't know me, my name is Steve Schwartz. I run the LSAT blog. I also host the LSAT Unplugged YouTube channel and podcast. And tonight I'm here with my good friend, Larry Lala. Larry, you want to introduce yourself and say hello?
Hi, I'm Larry Lala. My real name is Larry Lee. I've been a law school tutor for the last 9 years, and I have a site and YouTube channel as well, Larry Lala. And I just like to help law students do well in law school.
Awesome. Thanks so much for joining, Larry. And I'm really excited to be with you here in person. This is actually the first webinar I've done with the guest resident expert in person live. So that's very cool to have you joining me tonight. So I thought what we could do for tonight is just briefly talk a bit about the LSAT, a bit about law school prep. Then we'll open it up in general to your questions, whether they're on the LSAT, law school prep, or anything else. Probably not, ancient Roman history or something, although I'm interested in that. That's not my area of expertise. So LSAT, law school prep specifically. Larry, you want to just ask some general questions, get us jumping off?
Yeah, so something that I've noticed, I do get some of the chatter. Again, to be clear, I focus on students once they've gotten into law school and once they're in law school, but I still get some chatter on LSAT, and there's been a lot on it about the new digital administration of the LSAT. So I guess I'm wondering, how does that change how students should prep for the LSAT? And what's the same, what's different?
Yeah, sure. Thanks, Larry. So that's a great question. I guess what's changed is, and what hasn't changed, important to be aware of. First off, the content of the exam has not changed. You still have logic games, logical reasoning, and reading comprehension. That's all the same. You still have your experimental section as well. That's the same. But there are some important content delivery mechanisms that have changed, specifically how the LSAT is displayed on the tablet. So first off, it's not on a computer. It's not going to be like a full 8.5 by 11 PDF. It's going to be individual, bite-sized, one question being presented to you at a time. So you can't see all the questions associated with the game at once. You can't see all the questions associated with the passage at once. And you can't even see the passage entirely and the questions at the same time. So one big thing I would suggest is limit your field of vision, narrow it in some way. If you're using PDFs, maybe you enlarge the size of the PDF, or you take screenshots of individual questions to limit what you're able to see at once. The other biggest thing I would say is that you're used to, in your LSAT prep books, writing on the page, writing on top of the question. You can no longer do that. You will get underlining tools and highlighting annotation tools on the digital LSAT, but you won't be able to draw freehand like you would be able to on a piece of paper, for example. And so I would say treat your books like they were a computer screen. Treat your PDFs like they're on the screen. Don't use PDF annotation tools to draw on them with any sort of freehand notes you might otherwise do. Have your booklet of scratch paper to the side. LSAC will be giving you a booklet of scratch paper, maybe 14 pages, maybe 16 pages. They still have not confirmed the actual number of pages yet, even though we're less than a month out from the July LSAT. So just trust that you'll have enough, but not unlimited scratch paper to do with what you would like. As far as the July LSAT is concerned specifically, which I know many of you are taking, you mentioned here, July LSAT specifically is going to be a little bit different because this is their transitional test administration. Half of students get the paper and pencil format, half get the digital format. LSAC chooses for you, and you don't get any advance notice, which is a little bit nerve-wracking for some, but there are a few benefits to July as well. Specifically, they're going to let you see your score before deciding whether to cancel. And if you do cancel, they're giving you a free retake on a future LSAT administration. So with the LSAT costing about $200, that's pretty nice. That's a good chunk of change that you can save. And I think that anyone who does cancel on the July LSAT specifically, law schools will not look askance at that. They won't be too concerned about that because so many people will be canceling July, given that LSAC is giving folks an incentive to do so. So Larry, I know it's been a while since you applied to law school and you went through this process. How does this differ from what you went through? Any thoughts come to mind?
The Crimean War was going on at the time, and Yeah, I think this is all alien to me because when I prepped for the LSAT, I still did the prep tests on paper. Separately, to be honest, I don't think I spent enough time prepping in advance. I was working at the time, so I remember spending 2 months prepping for the GRE. I was applying for PhD programs at the same time, and I really only gave myself a month to prep for the LSAT, which was probably not ideal. It turned out okay, but I still wonder what could have been sometimes. So,
Wow, well, but Larry, you ended up going to NYU Law, so you couldn't have done too badly on the LSAT, right?
I did okay. I was going to say I knew a guy, but I don't even know what that means. I did not know a guy. Do you mind if I ask about something that came up? I think that you posted about, at least I saw it on your new Instagram account, about the limitation on the number of times you can retake the LSAT within a year. What is that about, and who does that advantage or disadvantage?
Yeah, that's a great question. I'm glad you brought that up, Larry. That's the other thing I was going to mention. And this just happened recently, actually. LSAC announced about a week ago. It was kind of actually leaked from their annual meeting around May 30th. Someone took a photo of a PowerPoint presentation they had. They were not planning to announce this yet, but anyway, LSAC, it used to be that there was no limit on the number of times you could take the LSAT, I believe. Then in 2017, they instituted a new limit saying you could only take the LSAT 3 times in a 2-year period, which is quite a limit. They removed that limit, so it was unlimited, which was great. That was part of LSAC's new campaign to be more friendly, in part due to competition with the GRE. So there were no limits at all over the past few years on the number of times you could take the LSAT. But now that they are starting to offer the LSAT more frequently, they're going to be offering it 10 times a year moving forward. They have to start reusing old LSAT test forms because it costs them $750,000 to create a new LSAT test form, a new LSAT prep test of 100 or so questions. So they can't just produce 10 new exams a year. That would cost them way too much money. They don't have the ability to ramp up like that quickly in terms of the production. And so to counteract that, they're actually going to create a new limit on the number of times you can take the LSAT. The details are on lsac.org if you want to see them all. And I'll send out an email to everybody after this webinar with the link to that as well. But basically now you can only take the LSAT 3 times in any one LSAT testing year, and only, I think, 5 times over a period of 5 years. Once you have, or 5 times in a 3-year period. And then once you've gotten a 180, you can't take it again. And you can only take it 7 times over the course of your life. So I know I've said a lot there, but the bottom line is that there are some limitations. It probably won't affect too many people because most people don't take the LSAT 4 times in a single testing year. But these are new limits. They are a result of LSAC's need to reuse old LSAT test forms. So let's say someone takes the Sabbath Observer's exam in February, then LSAC administers that as the June exam in Asia, then they administer it in North America in September. That could theoretically happen, and it does happen, but it's going to be happening more and more and more now that there are only 4 new exams being created a year, approximately 3 of which are released, and then they're administering it 10 times a year. So that is a new limit. Kind of interesting. I wish they weren't doing this because I think it's to the detriment of test takers, but that's what they've got to do. I hope that they figure out a way to create more new test forms going forward, because it's to the students' benefit to be able to take it as many times as you possibly need to reach your highest potential and get the scholarship money or get into a better law school, whatever it may be. So that's the deal on that, Larry, pretty much. Other thoughts?
Yeah, I guess this might be older just because I haven't dealt with LSAT in a while, but why have they gone to so many exams per year? I mean, this is still relatively recent that they've gone to 10. And why did they do that? If that's of interest to you.
Yeah, I think that is, folks are interested to hear that most likely. I think that basically LSAC has significantly ramped up the number of test administrations because they want to be more accessible. They want to be more friendly. Many law schools have in the past few years started accepting applicants with GRE scores. Not that many people. I've talked to a couple of folks. I talked to Rob Schwartz, the Dean of Admissions at UCLA. I talked to Kristen Mercado at UC Davis, and both of them said, and the interviews are on YouTube, by the way, if you want to listen to those or watch those interviews. But basically, both of them said that fewer than 5% of applicants who were accepted had applied with GRE scores specifically. So most students are not applying with GRE scores, but LSAC is still very concerned about competition from the GRE because the GRE is administered on the computer already, has been for many years now, and is available to take pretty much every single weekday, 12 months a year. The LSAT previously was only 4 times a year: February, June, September, or October, and then December. So 4 times a year versus nearly every weekday. Obviously, GRE wins that one. So LSAC has looked to ramp that up and said, well, we can do 10 times a year, which is pretty good, nearly every single month. Now, instead of having to wait 2 to 3 months to retake if you feel that like you need to, now you've only got to stay fresh on the LSAT for another month or so at most. So that's pretty appealing. So they're doing their best. And the LSAT, of course, is much more difficult to create than the GRE is. GRE, they can just substitute new math questions or new vocabulary questions, new vocabulary words, new numbers for different math problems. Very easy. The LSAT, on the other hand, has such intricacies of language that I think it just is not possible to create new test forms that easily, new test questions that easily. I talked to one guy who's a former writer of actual LSAT questions, and he told me that they might take 1 out of 10 questions he proposes to them or submits to them or writes. They would only take 1 question out of 10, and that was considered pretty good. So their standards are very, very high. It takes a tremendous amount of work to create a single new LSAT question or a single new test form. And so they're doing the best they can. They can't do more than 10 test administrations a year, at least for now. And it would cost them a ton of money to create more tests. Like I said, it cost them $750,000 to create 1 test form, and that number might even be outdated at this point. So that's why, but they can't go beyond that. And so that's going to lead them to be a little bit less transparent, unfortunately. Not ideal, but most serious law school applicants should be taking the LSAT anyway, regardless. I think that GRE typically applies to those who have some sort of unique background or work experience of some kind. But for the average person, the average pre-law, the average humanities or political science major, the LSAT's probably the way to go. So I know we've said a lot on the LSAT right now, and I know we've got some questions here we'll get to later, but for now, I do want to turn over to you, Larry. You've got a wealth of knowledge. You went to NYU Law, your Order of the Coif, magna cum laude, I believe. A lot of great credentials. You've got a great law school prep course and a lot of information to share. So I want to turn it over to you and just ask a couple of general questions. First off, when should folks start prepping for law school, and what are some common mistakes they make in the first semester or lead up to that?
Sure. I mean, those are the 2 most important questions, actually. I think there's that old, I think, Chinese saying, the best time to have started was 20 years ago. The next best time is today. I think a lot of people, if you go to like top law schools or Reddit, you'll see people asking the question, should I prepare for law school over the summer? Should I start preparing before? A lot of the answers put up by current or recent law school graduates will say, no, there's nothing that you can really do to prepare for law school, or it's a waste of time. I think that answer is simply wrong. I think that if you prepare the right way in advance, it's immensely helpful and can give you the edge over other students in law school. The hard fact is that law school is graded on a strict curve, and that most of the benefits of law school, and I think this is even true amongst the elite law schools, but most of the benefits of going to law school go to those people who graduate in the top 10, top 5%. So to get there, you have to have some kind of edge over other students. I hate to talk in terms of this kind of competition. I went to a friendly law school, and my friends from law school are friends. I mean, I really, most of the people I keep in touch with are from there. But the hard fact is, at least on paper, you're competing with your friends and colleagues. So what is it that you can do? I think I do agree that there are things that, there may be ideas that people who don't know anything about law school, who do want to prepare in advance, kind of come to this with bad ideas that like, oh, I should buy the case books and read them in advance. I can give you a longer answer why you shouldn't do that, but you should not do that. Let me bridge the two questions. The first question was, what can you do in advance of law school or before you kind of get there? The second question is, what are the mistakes that people make first semester? And so I think I would bridge those by saying, if you prepare the right way, if you focus on the right things in the summer, that's the best possible way to prepare. But even if you don't prepare over the summer, if you focus on the right things during the semester, you can kind of avoid getting mediocre grades. So what do I mean by that? And I think this advice can sound counterintuitive, but it's super important. Most of the people who go to law school are good students, type A, otherwise they wouldn't be at a good law school. What I mean by that is that you're not the kind of rebel or entrepreneur that says, I'm not going to do what you tell me to do. Most people are in law school because they're really good at showing up in class and doing what the professor asks you to do, doing all the reading, showing up for all the lectures, and following up on that, and then kind of giving that back to the professor. If you take that approach to law school, if you do literally what you're told, that's the recipe to end up in the middle of the pack and not get top grades. Why is that? There is a fundamental disconnect between what you're asked to do, what 90% of your law school, what your first semester in law school is about, if you do what you're told, and what you're graded on. Your assignments during the year involve reading a casebook and being asked questions about the cases that you read about, actual legal disputes that are resolved by usually an appellate court. That's what you get. You don't get a textbook, you get a giant book full of cases. And if you've watched The Paper Chase, the professor spends it's still usually his time grilling students about the case. So you read a ton of these things. There's a lot of reading to keep up on. It's a full-time job just to read the cases. You show up for class. You don't want to look stupid in front of your very smart law school colleagues. And so that drives you to read and do that. The problem is your grade, 100% of your grade is dependent on the final exam. There's usually not midterms. Some more law schools are doing them, but they're not worth very much. And in the end, your grade depends on how well you do on an exam, but it's not an exam that you're used to. Most college exams, at least of the social science or arts and sciences ilk, involve kind of synthesizing and returning information to the professor that you learned during the semester. It's a test. They're usually tests of knowledge. I don't want to dismiss how hard college exams can be, but usually what the professor's testing is, did you listen to me? Did you do the reading? A law school exam is not quite like that. What you're presented with is an actual legal problem. It's something more akin to a math test where you learn about concepts and you don't get to see, you're not regurgitating knowledge. The test is whether or not you can apply the ideas that you've learned to completely new situations. And so in this case, a law school exam is about solving an actual legal problem, kind of developing claims on behalf of the parties and figuring out how things will be resolved. Those are not skills that you learn reading cases and being grilled on them. So if there's one thing that you take away from this webinar, it's that you need to practice. You need to practice the end game. I've been talking about the end game because it's it's apparently the first thing that you learn in chess is how to actually finish the game off. But now that Avengers came out, it's now more pop cultural, which is what I'm all about. But the most important thing is that you practice taking exams. That that may be a hard thing to kind of swallow at the moment. How can I take an exam until I kind of have gone through the course? There are ways to do that, but if you focus relentlessly on learning how to solve legal problems, that is the kind of thing you should focus on over the summer. And if you keep your eye on that ball during the semester, even if you don't prepare over the summer, I think you'll be a lot better off than your peers. And if you want to be friendly and there are people that you care about, you would spread that news to them as well. So I think that's a really high-level way to answer your questions.
Thanks for that really detailed walkthrough, Larry. It's really helpful to have the background. And I'm constantly amazed at the similarities between LSAT prep and law school exam prep. One thing you said that really stood out to me, Larry, was the idea of it being like a math problem where you're not being tested on the readings in terms of having memorized information in order to regurgitate it. On the LSAT, it's the same thing. You're not memorizing information. Flashcards are of extremely limited usefulness. It's really much more about a way of thinking. And I've heard this before, kind of like logical reasoning on the LSAT is similar to issue spotting on law school exams. So I'm hoping that you can speak a little bit to that in terms of like the principal application sort of thing we see on logical reasoning, where it might be similar to law school cases in terms of issue spotting and general principles. And just for those who aren't aware of Larry's resources, I want to send everyone to Larry's website in order to get a better sense of what he has to offer. But anyway, Larry, if you could speak to that, it would be useful.
Yeah, sure. I mean, for me, the game section was a really, really long time ago, and sometimes I see LSAT blogs like yours and kind of look at that material, and I'm still stunned that so many of you have to actually learn that because it's immensely complicated. There's one area where I think the games sections of the LSAT is useful in law school, and it's a specific sub area of property where that tends to be super useful. I think more generally, the difference between skill and knowledge is I feel like knowledge is something that you can cram and skill is not. I mean, you're actually, to kind of talk about the biomechanics of it, developing a myelin sheath in your mind, that's the kind of pathway that insulates neurons. And it's what happens when you're learning a complicated physical skill like riding a bicycle or I don't know, I like to surf. Surfing is something that's muscle memory. And I think that a lot of the LSAT is like that. It's not kind of, you can kind of passively watch videos and understand how to execute on logical reasoning problems, but you can't really say that you know how to do it until you, actually have practiced the problems and can do them. I think one other commonality is the time pressure that you're under. You have a very short amount of time to finish a law school exam. This is different from real life in that you will have time, a little more time. You're not going to ever just be forced to figure out a legal problem in 3 hours, which is typically how long an in-class exam is. So I think the importance of practicing and working through difficult problems and carefully tracing if you've missed points, what you've done wrong. I think that high-level set of skills that you have developed in trying to get better at the LSAT will help you a lot in preparing for law school exams.
Thanks for that, Larry. That helped a lot. So if you wouldn't mind, do you think you could maybe walk us through what an example of a law school case might look like in terms of how we might extract, or like a scenario where we might be extracting different pieces of this real world case situation in terms of the issues that we need to be looking for to maybe classify something? I haven't gone to law school personally, so I can't speak to all the details, but I'm hoping that maybe you have a sense of what I'm getting at here and you can give us an example. I remember that within your prep course, you had this example with Spider-Man and Batman and made it real world and engaging. So if you could speak to that a little bit.
Sure. Let me try to take it from two different ways. I'll start by taking you from where you will be in law school. And that is, you you theoretically do have materials that I think if the professors took a different approach to them, what you do in class and reading cases would be more helpful in terms of prepping for the exam. But professors explicitly don't. There's honestly a lot of hiding the ball that happens. There's this general, you spend a lot of money to go to this institution. I think I'm slightly going on a tangent, but it'll kind of come back to the question that you've asked. You kind of infer from the professor wearing a bow tie and ivy hanging from the expensive walls of the law school that you go to, that there must be some method to the madness that you go through, that there must be some connection between the totally random set of cases that you're reading and what you'll be tested on. But there isn't. There's a huge disconnect. And when I talk to some law professors, some of them seem to be aware of this. Many of them are not or are indifferent to that. So let me walk through what does it mean to kind of read a case. You'll get a very specific set of facts. One of the most famous cases is Hawkins versus McGee. It's the very first case that the hero of the paper chase gets called on by John Houseman. I mean, he just says, I don't think this really happens that much anymore this way in law school, but recite the facts of Hawkins versus McGee. So the student has to, it's this case where a kid, it's a contracts class, and this person was supposed to get a transplant of skin. His hand was kind of burned or something like this, so he's supposed to get a transplant from his chest from this. And I don't know what, I didn't even know this was possible 100 years ago. I think this is how old the case is. So they cut a little bit of skin from the chest and transplanted it to the hand. The contract was for 100% whole hand, and you learn that in contracts, the way that you ask for damages involves like getting the benefit of the bargain. So what the person had contracted for, I can't remember if it's Hawkins or McGee at this point, was a completely good hand. Instead, because the skin was cut from his chest, he got a completely hairy hand, which is not what he had bargained for. And the facts, it's a pretty vivid case when you think about like transplanting chest skin to your hand. And so as a good kind of college student, you would read every word of that case and try to have every bit of the facts at your fingertips. Most of that is not something that you'll use. What you need to get out of the case is the idea of the benefit of the bargain. So there was all this pain and suffering. This is the core of the case that gets forgotten. The guy went through all this kind of pain and suffering. What the court did was to say that he could not collect on that pain and suffering to the extent that he would have had a giant square of his chest skin cut off anyway. That was part of the benefit of the bargain. There's the whole hand, but also the fact that he was going to go through some baseline level of pain and suffering to actually get the whole hand. Okay, what does that have to do with anything? If you're approaching this from the wrong way and that you're not looking towards the end game, you think that all that matters are the little itty bitty details, like, oh, did the doctor sign the document? Did the doctor, where was this in court? What was the procedural posture? Was it, how far up did it get? Did it get to the state Supreme Court? There are all these little details that until you understand what you're eventually going to be tested on, you'll try to embed in your head. That will fill all of your time. So what you want to get out of the cases are these really simple principles, but you can get them from kind of commercial outlines that will just say Hawkins versus McGee is about expectation damages, benefit of the bargain theory of contracts. That's what you need to get out of that case. Notice that there's nothing there that causes you to have to solve a legal problem. The work has been done for you. Both of the sides have presented arguments in the case segment that you're reading, and the case has been resolved. So what the professor's asking you about in class is, what would you have argued if you were Hawkins's lawyer? What would you have argued? What else might you have argued if you were McGee's lawyer? Did the court get it right? But you've already seen, as it were, all the cards being dealt. You have to develop all of that from scratch on the exam. You just get the kind of facts that someone burned his hand and had to have a skin transplant and wanted to enter a contract, period. The arguments are not developed for you, nor is the likely outcome of that case if it gets to court. So, the kind of online course that I have develops a lot of kind of bizarre scenarios, and I try to mix different pop culture characters. I have one that involves Thelma and Louise, which is kind of an older movie, and Gregor Clegane, the mountain from Game of Thrones, being like Thelma's abusive husband. And so I try to make it relatable, because a lot of the times on the exam, the facts are very dry. If it's a little bit alive, it's a little easier. Like, you can see that person in your mind, and then you can begin to develop. If you feel like you understand the situation a little bit better, it's easier for you to develop arguments for Thelma, for the mountain, for Louise, because she was just in the car when it went over the cliff, and then begin to actually solve real legal problems that way. So, sorry to kind of take one step back. To me, that's what solving a legal problem is. You're told a story. In the case book, that story is already analyzed. And then you're already playing with it, like, as a food critic who didn't have to cook the food, and you even have the benefit of other critics, like there was a court that decided these cases. So you're like, was this critic right? Was that critic right? Would you have added more oregano to this? And it's really easy to be a critic, but that's the position that you're in 90% of the time during the semester. On the exam, you're the chef. You have to kind of, from scratch, develop arguments on both sides, develop ones that the professor will recognize as competent legal arguments, and then to make predictions. And it's necessarily probabilistic. You would never, only kind of bad lawyers say, oh, this is a slam dunk. Nothing is ever as good or as bad as it might seem. But you still have to offer some kind of resolution as to, not only, so you've constructed pro and con on different sides of facts, and then you need to offer some kind of prediction as to who will win. And then you have to do this repeatedly on an exam, and do it within 3 hours, and do better than the rest of your classmates. So I think, I'm sorry, that was a very long answer to that question, but.
Well, thanks, Larry. That was interesting, though. I really liked how you made it real world relatable. I like the example of Thelma and Louise, and even the case of Hawkins versus McGee from the Paper Chase movie. I think it's important to recognize that, first off, these things have been analyzed by many other people, and so you have the benefit of their criticism. And secondly, I love the point you made as well, that it's not cut and dry. There's not obviously one side or the other that automatically wins. And that even reminds me of the LSAT writing sample, where you're given a situation of two sides equally weighted. You pick one, argue in favor of it, but you have to acknowledge that the other side also has some fair points. It's not obviously option A or obviously option B. Things are more complex than that. And so that actually relates to one question we have from the audience here. I thought it might be fun to get into some audience questions here. One person's asking, do you ever have to argue both sides on a law school exam, or is it usually just one side? Oh, you want to take this?
That's actually a great question. And my answer is yes. Let me say what I mean. There is a meta skill that the professor is looking for, that the professor doesn't tell you that he's looking for. And it's something that I would call, I'm still trying to find a better kind of buzzword for this, but it's legal judgment. When I say, not every issue on an exam is 50-50, close questions. There's a range. There are some issues that actually are slam dunks, and you have to pick those up. There are issues where someone might not win, but the argument is what we would call colorable. That is a super important distinction. So let me back up. The specific answer to your question is kind of both. Sometimes you'll have to argue both sides because the facts point to a very close question. Sometimes you kind of follow the facts where they go. Sometimes the facts will point to a really easy question where the other side doesn't have a great argument, and you don't waste a lot of time with it. You say, this person would probably win this easily because blank. And you can kind of go through the range. The most important thing, the way that you know you've passed through the veil of sanity and into the insane world of becoming a lawyer is what I would call colorability. Here's what I mean by that. Remember that most cases are not developed by schizophrenic law students who are having to develop arguments for one side and develop arguments for the other side and then be a judge. I think that's why this kind of, the basic legal analysis is a super complex thing that you're being asked to do, and it makes me angry that the professor doesn't really explicitly acknowledge how hard, how many different tools you need to kind of do that well. But one of the most important things is if you can put yourself completely in the shoes of one of the sides. If you're an actual lawyer to someone, that client wants you to argue their side. Now, that's not the entirety of the legal analysis, but it's a part of it. And what you do is you don't just develop slam dunk arguments for your client. Sometimes your client's in a bad situation and doesn't have great arguments. All you can do is develop the best arguments that you can on behalf of your client. Sometimes that means you come up with something colorable. What colorable means, please keep this in mind, what colorable means is this is possibly not a winning argument, but I would not lose my license making the argument. There are actually rules that prevent lawyers from making ridiculous arguments or patently untruthful arguments, or those that are clearly contrary to the existing law. You can actually be sanctioned for that. So if you can develop an argument that is better than that, the reason you need to hear that is that's where the A's are. Everyone else will get the obvious points. But what the professor is looking for is sophistication in executing those basic things. But the thing that puts you over the top is being able to point out colorable arguments, those things that are not winners, but if you're before the right judge, you know, this is the kind of thing where you might assess, like, this argument only has, and this is not what you would say on an exam, but kind of the mental models, like, if a winning argument's like you would win, you know, 60, 70% chance that you would win, a colorable one is like 10, 20, 30%. Why are those worth raising? Sometimes your client's in a jam. I've had this. I've worked as a lawyer. I no longer work at a firm, but I worked at a big firm where our clients are all big companies. I worked at a small one. When you have individual clients, sometimes they do things that are not great. I had one client who simply failed to pay a bank back. And I'm like, this does not look like a great case. And he said, what can you do for me? So when you're put in that position, you kind of research different potential defenses or claims. And I came up with something that bought him time. I mean, it should have been the kind of situation where the other side just showed, and that's what they did. They were arrogant. They're like, this guy just owes us money. But the situation was a touch more complicated than that, and I kind of found a defense that helped buy him time. The judge didn't simply order him to hand the money over, and that gave him some time to kind of negotiate a settlement. When I developed it, I didn't think this is a winning argument. I thought this is the best I can do, and I won't be kicked out of the law as a practicing lawyer in developing it. So again, that's a long answer, but a lot of this stuff is a little bit complicated.
Thanks for that, Larry. It's reminding me of in debate when they have you make an argument for the opposite side of which you were assigned, or they might assign you to argue a side that you're not really in favor of, but your job is not to argue necessarily what you believe, but in the interest of your client or in the interest of simply the side that you've been assigned to deal with. So thanks for that. This person responded, that was great. Thank you. So
can I add just one?
Yeah, go ahead, please.
Sorry, I was going to add just one more thing. I think that the idea, the question that I guess Ijenma asked is super interesting because you only see one side of it. A lawyer has a couple of hats, at least a kind of trial lawyer does. In court, all you ever see, like when you watch a TV drama, most of what you see is the lawyer in his role as advocate. So the lawyer in court is only arguing one side, is always pushing back on the other side, is always trying to pick holes in the other side's arguments. But before that lawyer gets to the courtroom, she's a counselor to her client. And so that requires not having a kind of one-sided view of things. If you did that, so you have a role and you have to play that role correctly. When you're in court, you're all for your client. You actually have a professional responsibility to be a zealous advocate on behalf of your client, unless you work for the government. That's a different story. But when you're playing the counselor, you're counseling and you're offering flat, objective advice to your client, where you have to kind of see both sides, where you have to have anticipated what the lawyer on the other side, just like the bit in debate where you have to kind of present on the other side of the topic that you just presented on, you have to be able to think, put yourself in the shoes of the other side to ask your client awkward questions. So I think better legal procedurals show that process where you see, the lawyer talking to the client acting skeptical, and then in court, she's all fire and just, a tiger. But as a counselor, you do both at different times. On an exam, you have to kind of do both. You develop the arguments on both sides, and then you step out of that role, and then you act as a judge, interpreting case law and kind of predicting where things would likely land. So sorry, that's a little bit I wanted to add.
No, that's great. Thank you, Larry. And it's really interesting to hear not only about what to do to prep for law school, but also more about what lawyers actually do, aside from necessarily all the drama of TV and movies. And back to the law school prep side of things, we've got two questions that are somewhat related about law school prep. One of them is specifically, when we talk about the summer before law school, are we talking about the summer immediately before one starts law school in terms of starting to prepare? Or are we talking about, let's say, you just finished college, June after senior year, but you might not go to law school immediately. Is it too early to start prepping? And then when you do start prepping, how do you recommend starting to prep specifically to get used to law school exam style questions?
Those are also great questions. And I would also say, oh my stars and garters, I can't believe that there are people who want to prep right after college before you get to law school. So I think the earliest you should be prepping is when you know you're headed to law school. There's a book that I've recommended on my website called Planet Law School 2, and he has a totally insane prep plan that involves getting ready a year in advance. If that's you and you're not, so let me say something that's partly in Steve's interest as well. Do not multitask. If you're not in law school yet, just do LSAT. Don't start thinking ahead to law school. Once the LSAT's out of the way, once you've gotten into a law school and you've gotten into the best law school you can, you've got the best kind of combination of best law school and best financial package you can, then think about law schools. For some people, that's the spring, and I've definitely had students start to prepare as early as the spring. For practical purposes, a lot of people are going to law school right out of college. You need to finish college. You need to still get good grades and kind of live your life and enjoy the end of college. So practically speaking, that leaves the summer. And then, so the other part of that question is how you recommend prepping to get used to law school exam style problems. So let me, I can be neutral about, I do have a particular solution, but in the abstract, there are places that you can get law school exams in advance. Now, the problem is you don't know any law. What you can do is study commercial outlines. Now, what do I mean by commercial outlines? There are two big brand names, Emmanuel's and Gilbert's, and these are kind of classic law school supplementary materials. Most professors don't like them. I have an entire post on my website and Above the Law. That one eventually got me kicked off Above the Law, but we can talk about that some other time. As to why professors don't like those materials. But what you do is you can, what I've called pre-study the law. There is usually at the beginning of a Gilbert's or Emmanuel's description of all of the basic claims and defenses you'll learn in a given subject, like contracts. Now, in Emmanuel's or Gilbert's is usually 300 to 400 pages long. It can be very detailed. There is a short outline at the very beginning that covers the basics. And it's almost what you would use to study for the bar exam. A 30 to 50 page outline. It's the condensed capsule outline. And it will just, for instance, offer the core elements of a claim, like battery is an intentional offensive touching without consent, like 1, 2, 3, 4. And you begin to kind of learn what those elements are. That will enable you to kind of spot issues as you see just the bare fact patterns given to you. So you see somebody get punched in the face or somebody spits water on someone, you're thinking, oh, how can I, you need to have, so let me back up. You need to have what's called black letter law, at least some of it under your belt in order to begin to analyze exams. If you don't know any law, you can't do that. Notice what you don't have to do. You don't have to have read every case to be able to do that. There's a reason why I think you should still read the cases as you go on, but people will read them obsessively. Let's back off of that. In order to, in this early kind of preparing season, whether it's the summer, or you can even what I call side study during the year to kind of cut down on the time you spend at the casebook, you begin to learn the black letter law. The black letter law is the material that you use to apply to kind of create legal claims and defenses on exams. So there are two pieces, right? You actually get the subject matter outlines for contracts or torts or property or whatever. You pre-study that. You can just study the capsule outlines in the Emmanuel's or Gilbert's. And with that knowledge, you can get practice exams, which are available. You know, you can type in like practice law school exams or law school exam banks. And there are some law schools. Berkeley used to have a good one, but they just closed it to the public this year. A couple other schools, I think University of Kentucky, a couple of others have open banks that you can begin to start to work with. My own website, my course, tries to solve this problem by offering you snippets of law so that you don't even need to know any law in advance. And then you can kind of work on a hypo, and you can start small and kind of work your way up to more difficult problems. But that's basically it. You find an abbreviated way to study the law, to actually know the black letter law that will be applied on exams, and then you take some exams.
Thanks for that rundown, Larry. Super useful. I like the idea of building slowly, starting with mini versions of the law and building your way up, because obviously if you haven't gone to law school yet, you're not going to know all the law, and you don't want to do hundreds and hundreds of pages of reading right at the outset. So starting small definitely makes a lot of sense. Let's see. Any other questions here on LSAT or law school prep? I know that we've been going for a while here. We've talked a lot on LSAT, a lot on law school. I want to share with you a couple of other resources that we talked about earlier tonight, just that you have them available to you. Larry mentioned my Instagram account, which I just started recently. I have a very small number of followers, and so I'm hoping that you all can help me change that. So I've put my link there. I'm also going to share a couple of other links, including one about that LSAT retake policy change. I just put an article out there on the Instagram and the Facebook group about that. The link is the Google News link here if you want to find out more on LSAC's retake limit change that occurred recently. I'll once again share a link to Larry's website with the law school prep course there. Any other questions for this evening? Anything I talked about linking but didn't? I just want to make sure I cover everything here. For those of you taking the LSAT in the fall, just know that you've got plenty of time to study. You've got the summer ahead of you. Don't burn yourself out. You've got a good 3 months till the exam. We got one person asking me about my paid courses and the differences between them, and then about Larry's different courses and the different levels there. So my courses, I have 3 different levels: the Supreme, the Premium, and the Basic Starter one. And those basically cover different levels of access to materials. I'll put the link there as well. So for my courses, the Supreme includes access to my live online classes and Q&As and webinars. You can attend live, get your questions answered. If you can't make it, just email your questions in advance and I'll do my best to cover them during the class. The Premium level, you get access to the recordings a week later, but you don't get to attend live. Then for the Starter level, you get access to the foundational video courses covering the basics, but nothing more than that. The link I just shared walks through in a bit more depth on that. Larry, you want to talk a bit about your courses?
Sure. So I have 2 different courses. One is called, the course generally is called KTCOOLS, Kick the Crap Out of Law School. It's a subtle name and a mouthful, so KTCOOLS. The basic tier is KTCOOLS Prime. It has a lot of basic strategy videos where I kind of discuss a lot of topics in depth, but most importantly, it has those hypos that I described for the 1L subjects, starting small and kind of building up to more difficult problems. So again, the key there is that I feed you little bits of the law, so you don't necessarily have to know anything before you can begin to take these hypos and you get built up to bigger ones. I still suggest kind of studying the black letter law on the side, but my course is specifically designed to help you develop that muscle memory or the myelin sheath. The next tier is KTCOOLS Total, and that includes fuller exams and kind of 2L subjects as well. And then kind of older webinars that I used to have and that I will start again every so often, probably no more than monthly, but live courses that where you can answer questions in a form like this. That's only available to the KTCOOLS Total students. So.
Awesome. Thanks for the breakdown. There was one follow-up question on what your course is, Larry. Is there an expiration date if you purchase your course?
There is none. Once you purchase, say you don't go to law school this year, it's still open to you next year. So it's kind of a lifetime membership in the course.
Very cool. Thanks for that. And there was one other resource I wanted to share as well, actually. It was about, Larry and I did a class a few months back, and actually he basically was just presenting a ton of useful information. I want to share that link with everyone here because I put the recording on YouTube. And so if you want to watch, Larry did a great 90+ minute course walking through in detail his thoughts on law school prep. And so so I'm sharing that in the chat here. And then we got 2 last questions about the LSAT. One is, do I expect score distribution will be the same once the LSAT is totally digital? Actually, LSAC is still going to take at least 3 weeks to get your score back to you. It's not going to be instantaneous. It's not going to be 1 week. And actually for the July LSAT, they're taking about 6 weeks to get your score back to you because they're doing all sorts of comparisons between the digital version and the paper version during that transition period. So those of you taking the LSAT July 15th, you won't get your score back until August 28th. And so find something else to do for those 6 weeks. If you're like Larry, go surfing in Far Rockaway, do something to keep yourself busy over the summer. And even in the long term, in the fall, I think it will still take approximately 3 weeks because LSAC does super detailed statistical analysis of all the questions to see whether they performed similarly under test take conditions as to what they expected previously. And then this last question here, as far as drilling, what's the best way to go about drilling LSAT questions? I'd say do what works best for you. If you've got to drill questions by individual question type, do that. If you've got to do full sections of games, do that. It's about working on your weak areas in addition to doing full-length timed exams. And so you can do the questions by type out of the books of exams. Some people are selling books of exams broken up by question type. If you go on Amazon and search LSAT questions by type, you'll find some of these books where folks have licensed LSAT questions and then kind of reorganize them. Let's say you'll have a chapter on weekend questions, a chapter of nothing but strengthening questions, and so on. Or you can use categorizations online and then just kind of thumb through the exams yourself to walk through it. So that's pretty much it. We've covered a ton tonight, so I'm going to leave off here for now. But I want to thank everyone for coming. I hope you found this helpful. Please feel free to reach out if you need anything at all as you move forward with your prep. As always, you can reach me, Steve Schwartz, at lsatunplugged@gmail.com, or on the Facebook group or the YouTube channel or the podcast or anything else. That actually reminds me that same lecture, I put the YouTube link from what Larry did. I also posted it on the LSAT Unplugged podcast. I'm including the link here as well. So if you prefer to listen on the go, you can listen there as well. Larry, I'll just turn it over to you if you want to leave some final words for everyone.
Thanks for having me. I really love doing this. And check out my site, larrylala.com, or if you need to write me, I'm at larrylala.com. It's a lot of Larrys and a lot of laws. I think Steve posted all the links in the chat and on Facebook and all the various places. But take care of yourselves. Try to prepare for law school in advance. And at least this time around, my course closes on Thursday night. So if you're interested and you want to get ahead of the game, I really encourage you to sign up. Thanks for having me, Steve.
Thanks, Larry. Have a good night, everyone. Take care.